Hello everyone, and welcome to this week's Motor Trade Radio podcast. Powered by Motors, the driving force behind multi-site advertising. With Philip Nothard and Curtis Hutchinson, bringing you all the chatter that matters.
Well, Phil, you and I were just reflecting on the number of out-of-office emails we're getting bounced back at the moment as the industry, or some people in the industry, are on holiday. But the big industry stories are coming thick and fast, aren't they?
It is, yeah, and I am wondering how many holidays have been interrupted since the Supreme Court announcement last Friday.
Yes.
Evening or late afternoon. So I suspect that there would have been many people of a senior role within the sector, be it in the lending or dealer or legal or whatever that, or consultancy sector, that have probably had their holidays maybe interrupted based on that announcement.
I should imagine there was a lot of laptops opening up by swimming pools from Friday afternoon onwards.
There is, but we have got a different show again for you again this week. I think last week when we had the Nick Thomas interview in the second half of the show, went down very well with the listeners. I think they found it very informative and useful, and we've done the similar this one. But I think obviously there's a lot of headlines this week around the Supreme Court announcement to do with the discretionary commission case. But rather than try and do the headlines, we've done something slightly different this week, haven't we, again, Curtis?
Yeah, we have, because as you say, last week we devoted the second half to Nick Thomas from Shangan. Well, we're doing the same this week, so we're going to devote the second half of this pod to our exclusive interview with Jon Butler. Jon is the joint head of automotive at Geldards, the national law firm, and he's also the legal counsel to the Vehicle Remarketing Association. So he was the perfect person to talk to, and we sat down and interviewed him, and it's a great conversation because he does bring a lot of clarity to a topic that is very complex and very sort of interwoven with different elements, and Jon kind of cuts through it all, as you'll hear in the interview. We'll have the full interview after the midway break.
Yeah, and just to caveat it, that this interview was recorded earlier in the week. And so you are listening to a pre-recorded interview there with Jonathan. So things can change very quickly in our sector, as Curtis and I find out on a week-by-week basis. But so if there is anything changed, then this was recorded on Thursday, pre those changes. But you'll find that Jonathan, the good thing about the interview with Jonathan, and just to preempt it, that rather than just the facts, he does have an opinion on the finding and what it means to the sector. Yeah. So you will really enjoy that. So do as Curtis said, stay tuned to the second half.
Yeah, and he also does actually go through the legal ramifications for dealers. So it is worth listening to that to find out what they are. But also on this week's pod, we've got an extract from our interview with Wayland's CEO, John O'Hanlon. Now, we caught up with John recently, and at a particularly busy time for Wayland's because they just completed an acquisition. They'd taken on new franchises. So it's a fascinating chat and a wide-ranging chat. So we'll have an extract from that.
You're listening to all the chatter that matters on the Motor Trade Radio podcast. If you're a supplier and would like us to profile your business and reach our audience of dealer bosses, managers and decision makers on one of our dedicated supplier specials episodes, get in touch with Curtis and Philip at motortraderadio@yahoo.com.
And companies recently featured in our supply specials include Ivendi, the motor finance tech provider, ETT, who are shaking up AI dealer call handling, Generational, the EV battery health test provider, and MTC, a company that's disrupting the way dealer websites are designed and built. So if you'd like us to profile your business, then just get in touch with Philip or myself. We're both on LinkedIn.
You're listening to the Motor Trade Radio podcast, powered by Motors.
So headlines that we'll cover in the first half of this week's pods are from AM, Car Dealer, Motor Trader and Auto Express, including new car registrations drop 5% in July, although year to date is still ahead as the SMMT revises its full year forecast upwards. But van registrations fell in July for the 8th month in a row as LCV operators weigh up economic uncertainties, which prompted the SMMT to downgrade its forecast for LCVs. Meanwhile, the first eligible cars under the government's electric car grant have been announced, but as we record this, they're all from one brand, and we'll also round up the latest car makers to offer their own schemes, and a car supermarket offering its own incentive scheme for used EVs.
But first up, as Curtis said earlier, we're going to share a brief extract from our interview from earlier on in the week with Wayland's boss, John O'Hanlon, talking about last month's acquisition of the 3 sites from the HSH Motor Group. Let's start off by expanding on that acquisition of the HSH businesses. I mean, what was the attraction of adding these sites and the brands, and as Curtis said there, with Honda, JQ and Amoda to your portfolio?
If I could beg an indulgence, the first thing I'd like to do is just thank all our new colleagues and a lot of the Wayland's team for all the blood, sweat, and tears that went into the acquisition. Sometimes those smaller deals can be just as difficult and time consuming, but with this one especially, we had to change every single system in the business, from the DMS to actually how we did our visual health checks. So it's been an incredibly busy, sometimes frustrating, and hopefully getting to the rewarding stage. So firstly, it's a thank you for that. To answer your question, Honda, I've had quite a long relationship with. I've been an admirer of the brand, and it goes all the way back to those Ridgeway days. So maybe a little bit more than 8 years in the making, Philip.
Yeah.
I was lucky enough to visit Tokyo in Japan, where we toured the plants. We went to Suzuka. We went to head office and met a member of the board, and I even spent time with Asimo, the robot. And it's quite an exciting time for Honda. They're really reinvigorating the product with 2 brand new EV products, lots of new hybrids arriving. I think that plays to some of the changes that have been made to the ZEV mandate. It's a retail brand, and now I've become an international dealer. Bristol and Cardiff is the biggest AOI for Honda for after sales in the country, and that plays to a lot of our strengths as a business. So, overall, that's really exciting. Amoda and JQ, we know it's a new entrant, and I think like any franchise decision, you can get really excited very quickly. But I always compare it to the marriage, where you can get very excited, but if it's not the right marriage, if it's not the right partner, it can be really expensive to get out of. So we spend our time, we did our diligence. We spoke not only to the brands, but also to a lot of the brand partners, and overwhelmingly, it came back very, very positive. And we've found, with Omoda JQ is, brands that are willing to listen, they're willing to invest, they're willing to collaborate, and to drive on. So all in all, we're incredibly happy, with the acquisition and with how the brands are now beginning to settle in.
And obviously, as you say, there's a lot of talk around the emerging brands, whether the Chinese new entrants or others, but predominantly from China. But as you say there, it is doing your due diligence, it's doing your background work, it's working with them. I mean, what is obviously from a strategic importance of adding those two brands to your business, your operation, your portfolio, but what's been your initial experiences as well so far? I mean, you just touched on it a little bit there. That they're willing to listen, they're willing to adapt
Yeah.
and work with you because they haven't got an existing network, and obviously they're after brand representation and volume.
I mean, the good news, because it's Bristol, it's an area. It's part of our area of influence that we have grown to understand, know more about. So it's from that position, we understand what we've got to do in the market. But 3 weeks in, and I can say it's genuinely been positive. They've been challenging around the key areas that you would expect them to be challenging around, whether that's been around, what's our goals, our ambition, our targets, right the way through to how are we going to achieve that round about marketing. And that's where, I've been reassured by the fact that yes, they're demanding round about what marketing we've got to do, but they're also willing to invest alongside. And that sort of working together, that cooperation, it really does, it just gives you the confidence to continue to invest in the brand.
And I mean, listening to Jon there, you can't help but, the respect that he gets within the sector and the business that he's building there and the speed in which he's building that business, Curtis, is phenomenal, isn't it?
Yeah, and Jon was very keen to talk to us after those acquisitions went through because we've been talking to him for the last few months, and we say, "Oh, Jon, you must come back on the show." And he said, "Oh, yeah," and he gave us a date, but it was very much around the acquisition, after the acquisitions, that he could talk about it, he could put some meat on the bones. And it is fascinating what he's saying about the three brands, so adding those three brands to the portfolio, but also he shares some of the sort of long-term plans because he's not going to stay in single representation with those three brands. He's looking to grow representation. So do check out the full interview because it's a fascinating insight, not just into the acquisitions, but Wayland's as a business, what it's doing at the moment and what its hopes and aspirations are.
Yeah, and his view on the market as well. So, as I say, I mean, the interview has gone down really well from earlier on in the week. So, if you haven't listened to it, it is in your podcast feed. So do check that one out. So, heading over to the headlines now, and like Curtis said, the first one comes from AM Online. As we know, the new car registrations and the LCV registrations came out for July this week. So in AM, new car registrations dip as buyers await electric car grant clarity. And this is saying that in July, the registrations fell by 5% year on year to 140,154 units. I think that takes the year to date to about 2.4% up year on year, but it's more about what's been happening in the private registrations and by fuel type that's the real standout in this one.
Yeah, and looking at the different sectors, so private was down 3.2% for the month. Fleet was down 6.5%, whereas business sales to those smaller companies under 25 vehicles was up 10.4%. So overall market down 5%. And it is revealing, isn't it? Because the electric car grants, well, we can't ignore it because it was announced in the middle of the month. Now, if you're a retail customer, you're thinking of buying an EV, you're going to wait, aren't you, until you know which vehicles are covered by the grant. So that would have had an impact on private sales, which, as I say, were down 3%. But fleet was also down, wasn't it?
It was, yeah. And I think, to your point there, I'm aware that some fleet operators are doing the same, because at the end of the day, it is new money, it's government money. So whatever they're negotiating with the OEM and the manufacturer for their discount structure in the fleet sector, the grant from the government, if any of those vehicles that they're in discussions with is eligible for either tier 1 or tier 2, would also be in addition to whatever they are negotiating or whatever terms they're on. So not only has it paused that private consumer, it's also paused a lot of fleet discussions as well, whilst they await full clarity of which vehicles, which manufacturers are going to be eligible and what tier they are getting any grants on, if any at all. So I think it wasn't a surprise. And you and I were talking before recording. I mean, a bit of context behind this. This is the start of a quarter, not the end of a quarter. So we haven't heard indications of that significant last minute tactical and pack deal activity that we saw at the end of June, which was about 54,000 units on the last day of the month in June. That doesn't seem to have been the case this time. There has been some, but not to that same level. So, it's the start of a quarter. It's not the end of a quarter. And obviously we've got September in this quarter as well, which is a significant month for the manufacturers.
Yes, and you mentioned fuel type, and again, a sort of fascinating snapshot of what's going on in the market at the moment, because registrations were down across hybrids. They were down 10%, petrol was down 15%, and diesel down 8%, while, as we say, battery electric vehicles, okay, we didn't know what the grant would cover, but registrations were up 9%. I would suggest they could have been up a lot more had that knowledge been in the market, because PHEVs, plug-in hybrids, were actually up 33%. So, and customers buying PHEVs would know that wouldn't have been impacted by the grant when it was announced, because that was only applied to pure electric vehicles. So a good month there for plug-in hybrid sales.
Yeah, and just before we share some of the numbers from across Europe, that from just adding context to Curtis there, that the year to date for battery electric vehicles, which is what the SMMT are calling out here, has risen from the same period of 2024 from a 16.8% market share, but it's still at 21.5%. So we're past the half year point. And this year's ZEV target is 28%. Now, obviously, it's not quite as black as white as there, but, supporting what you said there, Curtis, that the PHEVs, or the plug-in hybrid, that's moved from 8.2% to 10.5% this year. So, again, that year-to-date story does reflect the challenges in the marketplace still.
Yeah,
but if
you've got some European figures, haven't you?
Yeah, just some brief European figures, just to sort of say in comparison to where the UK sits. So France fell 7.7%, down to just over 116,000 registrations. Germany grew double digit, 11.1%, up to 264,800. And we've also got Spain in here that grew 17.1%. to 98,300. And finally, Italy fell 5.1%, so similar to us, but down to 118,500.
That's interesting on Germany, isn't it? Because obviously that came at a time when they were facing tariffs for anything that went across the Atlantic. So maybe there's some good incentives in the domestic market amongst the German manufacturers.
Yeah, and it had, it's been facing some challenges generally in the economy across Germany. So there is a growth, but it's from where they have been struggling a little bit in general.
So next headline is from AM Online, and it is light commercial vehicle market falls again in July as fleet confidence wanes. So this is news that this is the 8th consecutive month of falls for the light commercial market, which was down 5.1% in July, with 24,400 vans registered. And but the data indicates that last month, July, was actually the weakest July performance since 2022, and really calling out persistent economic uncertainty and low business confidence continuing to suppress that fleet investment.
Yeah, as you say, it's not a great story for commercial vehicles at the minute. Electric vehicles are still a challenge in the marketplace. They've also got the pickups around the new taxation rule around double cab pickups that's that's in now. So, they are facing a few challenges there. And as you say, I mean, full year now, I mean, they are down 11.3% overall. So in addition to that decline in July, we are 11.3% behind where they were for that same period last year, down to 179,481 from over 200,000 at that same point last year for those sub 3.5 ton. But it's a very mixed picture in terms of that fuel type as well and the type of vehicles within that sector.
Yeah, because battery electric vans posted another strong month, despite the overall market decline, with registrations up 73%. But that actually equates to just under 2,500 units, and it does reflect that the low base that it's coming from, because BEVs still represent just 9% of the LCV market in the year to date. So there's plenty of room for further growth there.
There is, yeah.
Especially as the ZEV mandate is set at 16%. So still a long way to go, and that's a tall order now for certainly this year.
And obviously, I mean, we moving on to the next story or the next few stories really around this electric car grant and what's happening in the sector. And over in Car Dealer, they've highlighted that the first cars eligible for government's electric car grant, or the ECG, revealed, and they're all Citroens. So Citroen Europe built EVs are eligible for the tier 2, I think it is, at 1,500 discounts. More models will be announced shortly. The government announces, and comes as car makers race to introduce their own equivalent scheme. So I think the Car Dealer have pulled out 6, haven't they? But I think there is a thing where some of them are the same models, just different derivatives within those models.
Yeah, so it's basically the C3, C4, the brand new C5 Aircross, and the E Berlingo. And as you say, they all qualify for the £1,500 grant on that tier 2 level set by the Department for Transport. But it is it's significant because this is the first manufacturer to actually announce the vehicles that qualify for the grants.
Yeah, and it is interesting, isn't it? I mean, you'd hope that, I mean, this was announced on the 16th of July, and I think we on that first podcast where we covered it, we talked through some of the complexity of the manufacturers having to submit their requests and information for their vehicles. Subsequently, some of the OEMs have sat down with the DBT and the DFT around this, but you'd expect a more robust process, and because obviously you've got a market that is trying to continue to evolve, transition to EV. Manufacturers are trying to get these vehicles registered, but having this uncertainty and waiting just can't be helping the sector, can it?
No, definitely not. And the complexity is really highlighted in the next story, which comes from Auto Express. And the headline there is Vauxhall pre-empts electric car grant with its own £1,500 discount. So this is a discount that Vauxhall has applied to the pure electric versions of the Corsa, Mocha, Astra, Frontera, and Grandland. Now, bearing in mind, some of these models share the same batteries underpinning and are manufactured at the same plants as the Citroen C3s that we just mentioned in the last story. So it's really highlighting that Vauxhall know that those specific models will qualify for the grant, but rather than waiting around for it to be announced officially, they've introduced their own scheme, their own electric car grant, and rather than sort of missing out and being part of Stellantis, that's really seeing part of the bigger picture, isn't it?
Yeah, and I think they're right in this. I mean, because obviously I think, and please correct me if I'm wrong with this, anybody, but that the announcement was that if the cars become eligible after the process of submission, then that is backdated to the start date of the scheme. So they probably are taking a bit of a bet here that there's no reason for those models not to get the same grant as the Citroen, because of obviously rules of origin and where they're everything else, that they're probably assuming that these vehicles will get that grant at that tier, and therefore any vehicles registered after the 16th or 17th of July will be eligible and backdated to that point in time. So they probably are taking a gamble there, should we say. But we may be reading a headline in a week or so say otherwise,
Yeah,
but hopefully not.
undoubtedly, yeah. And there's a really handy little roundup that Auto Sunday put out last weekend of what the various brands are doing to mitigate the electric car grant. And we've picked up on some of these over the last couple of podcasts, but it's a great table because it's an alphabetical listing of the brands and saying what their current offers are, whilst some of them are waiting for the grants to be announced, whilst some know that they won't qualify, so they've launched their own schemes. So we're rather hoping that Tristan Young at Auto Sunday updates this on a regular basis in the same way that he used to do for the, you remember he used to do that for agency,
Yes.
and which brands were going over to agency or what their plans were under auto retail. So it's a good bit of research, this.
It is, yeah, and I mean, just a couple there. We talked about Leap Motor with the equivalent 3750. Skywell have come straight in at the equivalent 3750. There's a couple of others that have come in at the tier 2. But what is interesting on the table at this point of publishing is that there's a few there: DS, Fiat, Peugeot, Renault, and Vauxhall, which actually Vauxhall might have changed a little bit because obviously we just read out that last story there. That actually on their website it says register your interest. So it's obviously, kind of trying to capture the inquiries and capture the potential orders ahead of getting clarification on those vehicles. So yeah, one to keep an eye on. But yeah, Tristan, if you can keep that updated and keep us informed, then that would be greatly appreciated.
If only for Philip and myself.
Exactly. But returning to car dealer and again, sticking to the electric car grant, BYD forced to act over ongoing uncertainty with its electric car grant. Status saying that the Chinese car brand still unsure if it will be eligible for government EV discount, saying that the grant will slash 3750 off the price of some electric vehicles under that 37,500 benchmark, as we know, and that most car makers still are waiting to hear if their cars are eligible, but only a handful, as we said earlier, such as those Citroen models, have already been confirmed being eligible for that smaller tier 2 grant. But BYD are obviously coming out of the blocks there with coming up an equivalent, but also obviously highlighting their disappointment of what is happening here.
Yeah, it's good proactive PR from BYD because they know, they pretty much know that they won't be eligible for the grant, and it's all again down to the rules of origin, where the cars are manufactured, how they're manufactured, and the batteries as well, and the impact on the environment of the power generation. So what they've done is they've launched a free 5-year servicing offer on a selection of its new EV models and even some used versions. And it's also increased the battery warranty that it has to 8 years and over 155,000 miles. And Steve Beattie, sales and marketing director at BYD, said he thinks customers are looking for more than just upfront savings, adding that customers want lasting value and assurance. While we may not currently be part of the electric car grant, we didn't want to wait to show our commitment. So I think a shrewd move, damage limitation. They're probably not going to qualify for the grant, but they've got an offer out there, and it is a good offer. It's a very good retail proposition.
I think it's a great offer. I think, considering it's not very new to the market, it's still reasonably new to the market considering all the manufacturers. I think the dealer network, tying these customers into that 5-year servicing is good for the dealer network. I think, that everything, bringing that consumer back to the showroom and that certainty around the battery as well in terms of that warranty. I think it's great news on that one. I think their value proposition in terms of price point is competitive anyway, isn't it? We know that. So I think this is a great initiative from BYD to counter the ECG that some other makes and models may get. Well, may not. We'll see. We'll see. But I think there is I thought you'd have picked up on this one, Curtis, in here, but there is a comment in this that
I was just about to
I'll
jump
hand it
in
to you.
because
I'll hand over to you on this one.
I saw this when it came out, and you would have done as well, Phil, because at the end of the story, they reference an interview that the global boss of BYD gave to the FT, where they described the grant. So the interview was just a couple of days after the grant was announced. And the global boss described it as being stupid and a bit of a joke, saying they are too small and too late. By the time they start to take effect, the market will already be saturated with Chinese EVs. So there you have it from the global boss of BYD, clearly unimpressed.
Exactly. So, and the final story of this first half of today's podcast, sticking with a similar theme around the grant, but heading over to motortrader.com. And this is that Big Motoring World offers a £500 EV deposit contribution on their used vehicles. So again, jumping on the back of this and trying to counter some of that new vehicle activity and maybe some of that new vehicle uncertainty, saying to the consumers, you know what, actually, if you're looking at something on an EV, then we've got an opportunity for you.
Yeah, it's a good move, and it's good to see the independent sector really sort of making the most of all this talk about EVs, because whatever you think of the electric car grant, it has raised EVs as a talking point amongst those who might be in the market to buy either a new or used. So what they've come up with is a £500 deposit contribution on finance taken out on a used EV, and they're going to run this until 25th September. And it's a good scheme because they would have seen a lot of interest, a lot of activity on their website in used EVs. And there's a comment here from Lawrence Vaughan, the CEO of Big Motoring World, who says record numbers of people are considering an EV for their next car, but there remains some fundamental barriers to uptake, and most of the existing incentives are only there for those who are able to buy new. For many first-time EV buyers, buying used will feel like a much safer stepping stone into electric than buying new. So we are introducing measures of our own to encourage and support those EV curious. I like the term EV curious, and I think this is a good move. It's well judged and certainly well timed.
No, I agree. I think we know that when the grant came out, a lot of the associations, the VRA, the BVLA, and others were calling for the government to come up with something for a used perspective, because we know the used EVs are entering the market now in volume, and there's something needs to be done. So I think it's a great initiative, and they are following it up with a big assist protect EV and hybrid warranty as well, which is available to purchase up to a 3-year package, in addition to the 12-month RACs, things that they get. So great initiative, and it's great to see that you've got used operators now talking a lot more about EVs, and obviously those incentives around EVs.
Well, that's all for this week's headlines, but we'll be back after the break with our interview with legal expert Jon Butler, discussing the ramifications for dealers of the Supreme Court ruling on car finance sales and why he believes it is a common sense judgment.
You're listening to all the chatter that matters on Motor Trade Radio. Powered by Motors, the driving force behind multi-site advertising. This is your weekly one-stop shop for all the biggest car retailing headlines from across the media, available on demand wherever you are on your podcast feed.
And now we're delighted to welcome this week's special guest, Jon Butler, the joint head of automotive at Geldards, the national law firm, and legal counsel to the Vehicle Remarketing Association. The big story still being digested by the car retailing sector is last week's Supreme Court ruling on how car finance is sold, and the subsequent move by the Financial Conduct Authority to launch a redress scheme for car buyers who believe they were missold finance under discretionary commission arrangements dating all the way back to 2007. Now, following the ruling, Jon posted a blog on the Geldards website, which neatly rounds up and explains the ruling from a legal perspective, which we really urge listeners to read. I particularly enjoyed the Motown referencing title, which is Stop in the Name of Automotive, a common sense judgment from the Supremes. Car finance claims take a hit, which kind of gives a flavour of where Jonathan's coming from. So we're delighted to welcome Jon to make sense of it all and discuss the ramifications for dealers. So welcome to the pod, Jon. Has the dust settled for you yet? I should imagine it's been a fairly intense period since last week.
It has indeed. Thank you very much for having me. The dust has settled a bit, but there's still lots going on.
Yeah. I mean, obviously we're recording this ahead of when it goes out. So, in the world of automotive and everything else going on, anything could happen, couldn't it, Jon? Before now.
It could.
Yeah. So, I mean, as I say, I mean, the dust has settled, but there's still a lot to sort of get through with this. And it seems a long while ago where we had your colleague on talking about when it was initially done or the case started, and now we've now got the judgment. So, I mean, obviously, it is a complex case for the sector, and for those that may not be as close as yourself, and I've been trying to follow it closely as well. And, for the sector, and it's complex for the car buyers. Could you give it some context and explain, in as briefly as possible, what prompted the Supreme Court's involvement?
Sure. Okay, so there were 3 conjoined appeals brought by what the court described as financially unsophisticated customers. And each of those customers had bought a second-hand car from dealerships, which also brokered the finance. As a result, the dealer brokers received a commission from the relevant lender that had either not been disclosed or only been partially disclosed. And the 3 customers brought claims in the county court alleging that the commissions paid by the lenders were bribes and that the motor dealer's acceptance of the commissions effectively amounted to a breach of what is called a fiduciary duty, for which the lender bore accessory liability. One of the customers, Mr. Johnson, he claimed that the payment of the commission made the relationship between him and the lender unfair within the meaning of the Consumer Credit Act. Now, all 3 customers were unsuccessful in the county court, either at a trial or on appeal. They then appealed to the Court of Appeal, where their appeals were heard together, and then last October, in the shock judgment, which surprised the sector and most lawyers, they were surprisingly upheld. And the Court of Appeal in that judgment basically said that in all 3 cases, the dealer owed the customer a disinterested duty and a fiduciary duty when performing their credit brokering role. The customer's informed consent to the payment of the commissions could only be obtained if they knew its amount. Mr. Johnson had not given his informed consent to the payment of the commission, and that relationship was therefore unfair. And as a result of that judgment and all the furore that was caused after it, both lenders appealed to the Supreme Court, the final Court of Appeal in the UK, and they handed their judgment down on the 1st of August, as we all now know.
And from a legal perspective, a legal point of view, what did the ruling encompass?
Well, there were a permission was given on 6 grounds to appeal, and I won't go through all those in detail. But the Supreme Court framed the issue effectively as this: does a car dealer who receives a commission from a lender for arranging finance in a transaction between customer, dealer, and lender, in which a car is bought on credit, owe a duty to the buyer of the car so as to enable that buyer to bring a claim against the lender for bribery or dishonest assistance or under the Consumer Credit Act? And as part of that issue, The sub-issues that the court had to look at was, does the law recognise a distinct tort, if you like, or wrong of bribery? And if it does, what's the nature of the duty or relationship between the dealer and customer that must exist in order for that bribery to be engaged? And then connected to that, what level of disclosure would prevent liability for bribery arising? And in Mr. Johnson's case, was the relationship between customer and lender unfair under the Consumer Credit Act? So the Supreme Court, in analysing those issues, decided unanimously that motor dealers acting as credit brokers do not owe a fiduciary or special duty to customers. They operate at arm's length, pursuing their own commercial interests. No reasonable person would think otherwise, nor do dealers pretend or promise otherwise. So they are not bound by the single-minded loyalty required of fiduciaries. The court said that the Court of Appeal had fundamentally misunderstood a dealer's role, and as a result, lenders couldn't be held liable for bribery or dishonest assistance by virtue of undisclosed commissions paid to the dealer. And only in Mr. Johnson's case did the court uphold a claim under Section 140A of the Consumer Credit Act that there was an unfair relationship. And it highlighted a number of factors that it thought were relevant for the purposes of deciding that that relationship had been unfair.
Now, Jon, you've actually explained what is a very complex ruling and background, and you've explained it in a easy to follow, easy to understand way. And as part of the analysis that you've shared over the course of the last week, you've actually got three key takeaways, which will really resonate with a lot of our listeners. What do those three takeaways cover?
Yeah, okay. So first of all, I think that now the industry will be able to assess really what their exposure is. I mean, this is a positive outcome for dealers. Lenders are expected to bear the compensation burden, not the brokers. But the lenders should now be able to determine with some certainty whether their brokers owe fiduciary duties, and at a high level will be better able to assess the likelihood of success of any unfair relationship claims made against them via the regulator or via the courts. That will help them determine their potential liabilities and make provision. It will also mean that dealers are going to have to look back historically at records, some going back a very long way, to work out what the transactions were, what they said, what they disclosed, what they didn't say, whether they've met the relevant thresholds. And thirdly, that will also help them decide how best to deal with ongoing claims that are still being widely advertised. I mean, you'll have seen that adverts out there, particularly by claims management companies, have not slowed. They're still out there. That adverts are still being put out there, which almost reflect the position before the Supreme Court judgment. I'm surprised actually that the FCA has not ordered that those adverts stop pending them rolling out the redress scheme. But people should now be able to see really and navigate where they're going with these claims and make sufficient provision.
And just really taking each of those takeaways in order. I mean, firstly, in terms of the payouts, what will this mean for the finance sector? There's been a lot of numbers and a lot of potential costs being talked about, which are fairly broad in terms of their estimations.
Yeah, the estimation is that there's going to be somewhere between, I think, 9 and 18 billion pounds. My own view is that figure may be to try and ring fence potential exposure, but it's probably implausible. It seems to me way too high. £950, which is being considered the maximum claim per agreement, divided into 8 to 10 to 16 billion pounds, whatever it is, 18 billion pounds, is looking at something like 10 to 20 million claims. Those claims, all to the required thresholds, seem to be highly unlikely. It's not impossible, but it seems that that's a lot of people who will have to prove demonstrably that they have been unfairly treated.
And probably the second one is obviously in terms of the legal obligations facing, as you say, those dealers, and we're talking about going back to 2007 here. I mean, and they've obviously started it since 2007. What was the reason for that, and what are the obligations now from the dealers?
The reason for that was that the FCA proposed that the scheme covers agreements going back to 2007 so that it's consistent with the Financial Ombudsman Service complaints that are already being considered. But whilst the FCA has said that it wants a scheme to be comprehensive and avoid the need for consumers to use other routes to secure compensation, and also to prevent large numbers of claimants going to court, it's unclear actually why anyone can go back to 2007 realistically when the limitation period for pursuing claims is typically 6 years. But be that as it may, 2007 is the date that the FCA has chosen so that it aligns with what it's already been done. And in terms of what legal obligations face dealers, first of all, it's meaningful disclosure. I mean, they're going to have to access somehow historic agreements. And the dealer groups that I've spoken to, there's just no chance that they've got data or documentation going back anywhere near that far. They didn't face regulation until 2014. So it's all very well saying that this scheme should be properly thought out and it should assess claims properly and rigorously and not arbitrarily. But how can that be done when claims from fairness are going to be inevitably highly fact sensitive? And if you don't have the data or the documentation to interrogate, how can anyone make a proper assessment as to whether a claim being brought is genuine or not?
And thirdly, and I know I've spoken to you a lot about this with the work that you've been doing with the VRA and others, that explain the indemnities that the dealers need to obviously check in their contracts with their lenders, and what happens if they find that there is indemnities, or what the case is, or with and without these indemnities.
Yeah, it's a great question. Invariably, dealers will have agreements with their lenders, and those agreements will contain contractual provisions which typically provide that in the event that the dealer's compliance or non-compliance or any other aspects of the relationship bring about loss to the lender by virtue of claims, regulatory prosecutions, fines, demands, whatever. However, the dealer's conduct has effectively landed the finance company in it. Because you have to remember that the dealers, they're the coalface, they're the ones that are dealing with the consumers. The lenders are beholden to the dealers to do their job properly. And to the extent that the dealers have not, then there may well be contractual provisions in the dealer agreements that say in those circumstances, any loss that the lender suffers should be paid for by the dealers. So it's good practice now for dealers to have a look at those dealer agreements and see if there are indemnity provisions in there, to take advice if they are in any doubt, but also if they are there, and they typically will be there, to obviously reflect on the commercial relationships that they've got with the lenders. Lenders need these dealers. They'll typically not fall out with each other. There are commercial means of sorting these issues out. But in the right circumstances, there will be lenders who might be looking to the dealers to reclaim some of the loss that they will suffer as a result of this redress scheme. And so dealers need to understand that. They need to work out what their potential exposure is for it and make provision.
And Jon, following on from that and looking at the FCA's redress scheme, which I think our understanding at the moment is that it will be set out in October with a clear deadline to be completed in terms of redress being made. sometime in 2026. And this is based on the Johnson versus First Rand ruling, where the commission paid on a car purchase made by the initial car buyer, Marcus Johnson, was set at something like 55% and was undisclosed at the time as a paid commission and was subsequently upheld by the appeal court. What are the legal implications of this for dealers? Because it's really focusing in on that unfairness, isn't it, of the actual commission paid?
It is, but the redress scheme won't be isolated. It won't be confined to that. The FCA has already indicated that they will be looking at agreements that contained DCAs or discretionary commission arrangements, so that those practices were banned back in 2021, where dealers are effectively incentivized to charge higher interest rates in return for higher commissions. That will be part of the consultation, as well as agreements that don't contain any discretionary element, such as the ones that we have been talking about before the Supreme Court. So the consultation will be quite broad. It may even go wider. The court made no mention of regulated hire agreements, not hire purchase, but hire agreements.
Yeah.
And nor does the Consumer Credit Act cover regulated hire agreements in Section 140 for these purposes. So it may well be that the redress scheme has got to broaden the scope yet further and consider whether commissions that have been effectively improperly paid in those circumstances ought to be subject to some form of redress. So it could be pretty wide, and I think, as we've already been discussing, the legal implications for dealers are they've got to look at how far they are exposed. They've got to go back through their paperwork, such as there is, and try and work out what potential exposure there is, and whether, as we've said, whether they are on the hook for indemnities by lenders.
Yeah, it's very complex, isn't it? I mean, I've heard dealers now that have since 2021 been accruing for potential interest rebate on that obviously I think there's is it 3% they put in, but it's an average. They average it, don't they, over the period. So some dealers have already accrued, hundreds and thousands up to millions of pounds in their accounts, just in case there is any redress that will be passed on to them in terms of those interest charges.
Yes,
so
and yet the dealers have to remember as well that we're looking at a period of 14 odd years, and there may well be customers who purchased maybe 3 vehicles during that period on PCP or HP arrangements. So there could be customers with 3 lots of claims. So they need to be obviously looked at. Interest, yes, you're right. It could be about 3%, I think 1% above base, or about 3 altogether. It's roughly going to be around that sum. If I could just add, even though the FCA has announced that these payments will start in 2026, I think that sounds pretty optimistic.
They didn't say when, John. They didn't say when.
No, that's right. They said hopefully implement this scheme in 2026 and payments starting in 2026. I suspect that could be the back end of 2026 at the earliest, because I just don't see how practically possible it's going to be. Because unless compensation payouts in demonstrably unfair cases are approved and quantified on an arbitrary basis without a forensic assessment having been carried out for each one, I just can't see how the FCA can logistically do it.
And do you agree with there's some people are challenging why it goes back to 2007, but some part of the sector believe that that's a good thing because it closes down the claim risks and because it's if you go back before then, but the actual case goes back to 2007, you run the risk of going back into the small claims or individual claims.
Yes, I think it probably is a good catch-all. It may not work in terms of logistics and trying to find documentation and data and information, but if it catches everything and gets this sorted out once and for all, then that's probably a good thing.
Yeah, I mean, it's fascinating, and I know, I mean, trying to get this into a 20-minute conversation to try and cover it is so complex. But I mean, just finally, you describe the Supreme Court's ruling as what you call as common sense judgment. I mean, what should dealers do now to ensure that they remain compliant? I mean, you touched on it a bit in terms of checking their contractual agreements, checking their indemnities, but actually thinking of going forward just to make sure that they are compliant to any exposure and the new rulings.
Yeah, it is a common sense judgment. I don't think anyone in their right mind was expecting anything else. This is not a huge surprise to the sector or the law firms up and down the country. I think everyone balked at the Court of Appeal judgment as being extremely odd. But looking ahead now, dealers need to go back to their historic commission arrangements to ensure that they fall within acceptable transparency thresholds. That's the watchword, transparency. They've got to monitor FCA guidance and any future scheme implementation, including obligations to participate or respond to consumer complaints. They need to prepare communication strategies to address existing customer queries and manage their reputational risk. There's probably going to be an obligation on all such dealers to notify their customers that they've got potential claims, even the ones that don't yet know. I mean, I'd be surprised if no one knows, but you're going to have to tell your customers that there are potential recourse out there. Dealers are going to have to audit their contracts with third-party claims handlers, particularly as we've talked about, where indemnities or referral relationships might be implicated. And they're also going to have to support internal teams in handling data subject access requests from consumers prompted by renewed public interest. Because even though I think widespread people know that something cataclysmic has just happened to the claims management environment, whereas there was or seemed to be clarity as of Friday evening on the 1st of August, by Saturday, the FCA had managed to confuse everybody and make sure that everyone then thought, actually, there's still billions of pounds of the claims out there potentially. So I think you are going to get consumers who've not yet signed up to claims management companies asking for details of data and agreements, etc., that are held by the supplying dealers. And they may well register with claims management companies to try and bring claims for unfairness, even though the courts are saying that, and the FCA is saying that they don't need to do that. And of course, there will be people who've already signed up to claims management companies wondering now what's going to happen to those claims.
Isn't there an exit fee?
Yeah, well,
I'm sorry to throw it in right at the end here, but there are consumers that have signed up to more than one claims, and there are exit fees that apply to these.
Well, doubtless there'll be people out there having booked world cruises on the back of promises that they're going to get thousands of pounds for each of these claims. And I suspect that they're going to be falling out with claims management companies before too long, saying I've been misled and I wouldn't have signed up to this agreement had I been told correctly that I didn't need to do so because I could have gone straight to the FCA. And then claims management companies are going to say, well, if you want out, you're going to have to pay us 175 quid to get out. And that's going to bring about claims that they've been treated unfairly. They'll go back to the FCA. The FCA will be dealing with unfairness in satellite litigation, let alone the core litigation about the particular treatment by dealers to consumers. So it's a bit of a mess. And the FCA is going to have to be very careful in rolling out this scheme, because if it's not careful, it could just end up reaping a situation that's far worse.
I could hear you laughing in the background there, Curtis. I mean, trying to make sense of it all, and
if you're a claims management company, you've got to kind of ask yourself: do you pursue these claims for limited unfairness now of a maximum £950 and take 36% of that and run the risk of the ire of the customer, or do you let the consumer out and fight out with the consumer over an exit fee of £175? What's your business model? Are you going to just going to guarantee yourself 175 quid in a fight, or are you going to run the risk of losing everything with all your investment for the sake of a third of 950 quid? Lots of these companies have ploughed a lot of investment into these claims, And now that the test is about unfairness on a highly fact-sensitive case-by-case basis, currently, they're going to have to put more and more investment into those claims to win them. Far more investment than they were having to do up until last Friday. And I imagine there'll be lots of CMCs now wondering whether their business model is actually viable.
Yeah, I think you're absolutely right, because that's a lot of £175. And I was particularly interested in what you were saying about the FCA potentially getting involved at some stage. So, as you say, that part of it is all a bit of a mess.
It is.
I mean, you could say this is a ever-moving situation, and there's a very complex and things like that. But I think you're trying to keep ahead of it. It's really great to have you on, Jonathan. And as I said, to try and contain this into sort of less than 30 minutes is a feast in its own right. But I mean, if anybody listening hasn't seen Jon's and Geldards' blog, then it's a great summary of the outcome and their opinion on it, albeit as agreed, what a great title on that one, and it's placed very much into Curtis's space with that headline.
I could just say, lenders and dealers were always right to fight this. It always seemed wrong, and I applaud them for seeing it through, because even though it's still not clear how it's all going to be resolved, they're in a much better environment now than they were before a week ago.
Yeah, and consumer lending in the broadest industry in its own right, into I think that it is contained to this, and it hasn't been let out into consumer lending and B2B lending, etc. That it's a good result, although it is going to still hit financially in some areas. It could have been a lot worse.
Yeah, absolutely.
But that's all for now. So many thanks to Jon for joining us, and many thanks to you for listening. Until next week, it's goodbye from me.
And it's goodbye from him.
Thank you for listening to the Motor Trade Radio podcast, powered by Motors, the driving force behind multi-site advertising. We'll be sharing all the URLs from this week's headlines on Monday morning. To make sure you receive them, just subscribe to the free newsletter on our LinkedIn page. Just search Motor Trade Radio Podcast.